Hey everyone, and welcome to This Explainer. Have you ever wondered what actually happens when an incredibly important landmark case reaches the absolute highest court in the land, and the judges just deliberately decide, nope, we're not going to rule on this right now? Well, today, we are dissecting a fascinating piece of South African legal history, Dudley v. City of Cape Town. It's a case that really forces us to look at how the justice system balances urgent, big-picture constitutional questions with, well, strict procedural rules. Here is our roadmap for today. 1. 2 doctors, 1 job. 2. The affirmative action sword. 3. Skipping the legal line. 4. The chain of command. And finally, 5. Not a final no. All right, let's jump right into section 1. 2 doctors, 1 job. You know, behind every dense, abstract legal theory, there are real people with their actual careers on the line, right? So the initial dispute here centers around a really high-level position, the Director of City Health for the City of Cape Town. On one side, we have the applicant, Dr. Lilian Dudley, a Black woman. On the other side is the selected candidate, Dr. Ivan Toms, a white man. Both of them are medical doctors. And when the city officially offered the job to Dr. Toms, Dr. Dudley formally challenged the appointment. Now, Dr. Dudley didn't just casually disagree with the hiring choice. She brought a formal statement of case, outlining some major claims. We're talking unfair discrimination, an unfair labor practice, and a breach of constitutional equality obligations. But her primary argument, the absolute anchor of this entire legal battle, was an alleged breach of the affirmative action provisions found in the Employment Equity Act, or the EEA. Which brings us to Section 2, the affirmative action sword. To really grasp her claim, we have to look closely at the Employment Equity Act itself. The EEA is a statute specifically enacted to give effect to the constitutional right to equality, mainly by eliminating unfair discrimination in employment. It's the foundational law at play here, and as you can imagine, interpreting it naturally raises some massive constitutional questions. So how did the City of Cape Town respond? They didn't just argue the facts of the hiring process. Instead, they filed what lawyers call an exception. In the legal world, an exception is a formal objection asserting that, hey, even if every single thing the plaintiff says is absolutely 100% true, those facts still do not establish a legally valid case. Essentially, the city told the court, even if her facts are right, the law simply does not allow her to sue us this way. The city made this really brilliant legal argument. They argued that affirmative action under the EEA is meant to be used as a shield, basically a defense an employer can use if they're accused of discrimination while trying to diversify their workforce. It absolutely cannot, they argued, be used by an individual as a sword to actively prosecute a claim and demand a specific job. And guess what? The labor court actually agreed with them. They upheld the exception, ruling that the EEA just doesn't establish an independent individual right to affirmative action. But here is where things get super messy. This whole sword versus shield debate built into a massive legal headache because, at the time, the lower courts were totally divided. In Dudley v. City of Cape Town, the labor court ruled affirmative action cannot be used as a cause of action. But in another case, Harmsay v. City of Cape Town, a completely different judge ruled that it can. You literally had 2 completely conflicting decisions coexisting within the exact same court system. So, how do we fix this? That leads us to Section 3, skipping the legal line. Okay, to untangle this, you really have to understand the standard ladder for labor disputes in South Africa. First, you start at the CCMA for mediation. If that's unresolved, you move up to Step 2, the Labor Court. For appeals, you go up to Step 3, the Specialized Labor Appeal Court, or the LAC. And then finally, for major constitutional matters, you'd reach the top, the Constitutional Court. But Dr. Dudley, she did something highly unusual here. After losing at the labor court stage, she actually applied for direct leave to appeal straight to the Constitutional Court. She attempted to completely bypass Step 3, the Labor Appeal Court, entirely. And this brings up a massive, really provocative question. Should the absolute highest court in the land intervene directly to solve this affirmative action dispute? Dr. Dudley argued, look, this issue affects employers and employees nationwide, and a direct appeal would save everyone vast amounts of time and money. Honestly, it's a pretty compelling argument to just cut to the chase, right? Let's see what the judges thought in Section 4, the chain of command. Well, the Constitutional Court's stance was rooted in a very deep respect for the existing legal structure. They stated clearly the LAC is a specialized appellate court that functions in the area of labor law. They really emphasized that these lower courts were specifically established to oversee, interpret, and develop this exact type of specialized jurisprudence. So, ultimately, the court unanimously refused the direct appeal. Why? First off, bypassing the system denies the Constitutional Court the immense advantage of the Labor Appeal Court's expert judgment. Second, the LAC really needs to resolve that glaring conflict between the Dudley and Harmsey decisions itself. The highest court found no compelling reason to jump the queue, noting that the specialized court is perfectly capable of dealing with the matter speedily on its own. Which brings us to our final section, Section 5, Not a Final No. Now here is a somewhat ironic twist. While the Constitutional Court rigidly enforced the legal ladder, they were actually quite accommodating on other procedural matters. Dr. Dudley's application to them was actually filed 5 days late. Yet, showing a bit of procedural grace, the court forgave the delay. They also made no order for costs against her, ensuring she wasn't financially penalized just for attempting this legal shortcut. And this is absolutely crucial. The court cited a previous case stating, "An order refusing leave to appeal directly to this court does not preclude the litigant from approaching this court again." This is such a vital legal principle to take away. Passing the buck down to the lower specialized court is not the same thing as throwing the case out forever. A not right now isn't a never. So what happens next? Well, because Dr. Dudley had very smartly filed a conditional application to appeal to the Labor Appeal Court just in case, that process could now proceed. She simply had to go back and fight her battle on the correct step of the legal ladder. The highest court was waiting, for sure, but only after the labor experts had their say. So I want to leave you with this to ponder. In the pursuit of fairness, is it more important to get a rapid decision from the highest court or to ensure that every single step of the legal procedure is strictly followed? It's a tough balance. Thank you so much for joining us for this explainer. Keep questioning, keep learning, and we will definitely see you next time.